The opinion that ended 49 years of constitutional doctrine begins, oddly enough, by conceding ground. Before the holding, before the citations, before the page upon page of historical analysis that would follow, Justice Alito sets down a single sentence about the country itself. The court's very first words in Dobbs are not about law. They are about Americans. The sentence reads, and I'm quoting directly, "Abortion presents a profound moral issue on which Americans hold sharply conflicting views." That is the first sentence of the opinion. It does not announce. It acknowledges. The court, before doing anything else, locates itself in a country that does not agree about the question it is about to decide. And it asks the reader, at least implicitly, to hold that acknowledgement in mind as the rest unfolds. The question, in 2022, was already an old one, older than most of the people arguing about it, old enough to have generations of doctrine layered on top of it. To understand what the court did in June of that year, you have to understand the two cases that came before. In 1973, the Supreme Court decided Roe v. Wade. The opinion before us records the moment in 11 words. Then in 1973, this court decided Roe v. Wade 410 U.S. 113. Roe held that the Constitution protected a right to obtain an abortion. The court built that right out of a substantive reading of the Due Process Clause of the 14th Amendment. It tied the scope of the right to a trimester framework with the line drawn at fetal viability. That decision would govern American abortion law for the next 19 years. And then in 1992, the court returned to the question. The case was Planned Parenthood of Southeastern Pennsylvania v. Casey. A deeply divided court reaffirmed what it called the central holding of Roe. It discarded the trimester framework. In its place, the court put a new standard. A state law was unconstitutional if it placed an undue burden on a woman's ability to obtain an abortion before viability. And here is where it becomes worth slowing down, because the reason the Casey court gave for keeping Roe was not that Roe had been correctly decided. The reason was stare decisis, the Latin phrase for the principle that courts ought generally to stand by what they have already said. Casey, in other words, did not rest on the strength of Roe's reasoning. It rested on the weight of Roe's existence. Skip forward 26 years. In 2018, the Mississippi legislature passed something it called the Gestational Age Act, codified at Mississippi Code Section 41-41-191. The statute prohibited most abortions after 15 weeks of gestation. There were narrow exceptions for medical emergencies and severe fetal abnormality. The legislature did not pretend this was a small adjustment to existing practice. It was a direct, deliberate restriction, reaching well before the viability line that Roe and Casey had drawn. The act came with what lawyers call legislative findings. These are statements the legislature itself wrote into the statute about what it believed to be true when it passed the law. I want to be careful here. These are not adjudicated scientific facts. They are not the Supreme Court's conclusions. They are Mississippi's reasons, in Mississippi's words, written by Mississippi. And here is what the Mississippi legislature found. It found that a fetal heartbeat could be detected at 5 to 6 weeks. It found that fetal movement was observable at 8 weeks. It found that by 10 weeks, all of the body's vital organs were functioning. And it described the dilation and evacuation procedure used for many later-term abortions, in its own chosen word, as barbaric. Whatever you make of those characterizations, they are the legislature's, and the script will treat them that way. On the day the act was enacted, the Jackson Women's Health Organization, an abortion clinic, and one of its doctors filed suit in federal district court. They sued various Mississippi officials, including the state health officer, Thomas Dobbs, whose name would eventually attach to the case. The clinic's argument was straightforward. Under Roe and Casey, a 15-week ban prohibited abortions before viability, which meant the act could not stand. The district court agreed. In 2019, the United States District Court for the Southern District of Mississippi granted summary judgment for the clinic and permanently enjoined the state from enforcing the act. The court's reasoning rested on a single doctrinal proposition that had governed this area of constitutional law for 46 years. In the court's words, viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a ban. 15 weeks falls before viability. The act could not stand. Mississippi appealed. In December of 2019, the United States Court of Appeals for the Fifth Circuit affirmed. Now the clinic had won twice. The lower courts had applied the precedent the Supreme Court itself had set down, and the precedent had pointed to one answer. And then Mississippi did what every losing party with the resources to do so eventually does. It went to the Supreme Court did not arrive as a frontal assault on Roe v. Wade. It arrived as an argument about a single number, 15 weeks. Mississippi had drawn its line at 15 weeks, and the court had agreed to decide whether that line could stand. In 2021, the justices granted certiorari. The question they took up was narrow on its face, whether all pre-viability prohibitions on elective abortions are unconstitutional. That was the formula. That was the doorway in. Through that doorway walked something much larger than 15 weeks. Because to answer the question Mississippi had posed, the court had to do more than measure one statute against an existing rule. It had to look at the rule itself. It had to look at Roe. And so the case, which began as a question about Mississippi and 15 weeks, resolved itself in the end as a question about Roe v. Wade. Justice Samuel Alito, writing for the majority, did not begin his analysis with the Mississippi statute. He began with the 1973 decision, and he asked, plainly and at length, what kind of right Roe had recognized. A right to abortion, the opinion explains, is nowhere mentioned in the Constitution. The word does not appear. No clause names it. No amendment protects it. For its first century and a half as a republic, no federal court reads such a right into the founding document. That silence in the majority's reading is not an oversight. It is a fact about what the Constitution does and does not protect. And if a right is to be protected by the 14th Amendment, the majority continues, it has to come from somewhere. From the text, from history and tradition, from the broader concept of ordered liberty. Nor, in the majority's reading, was the right deeply rooted in the nation's history and tradition. At the time the 14th Amendment was ratified, the great majority of the states made abortion a crime at every stage of pregnancy. That was the legal landscape into which the amendment was born. That, the majority insists, is the landscape against which any claim of a substantive due process right must be measured. And so the majority arrives at its conclusion. The right Roe announced in 1973 was not implicit in the concept of ordered liberty. It was, in Alito's framing, an act of construction. The court of 1973 had not found a right. It had made one. To press the point, the majority reaches back nearly half a century, to a dissent written the same day Roe was decided. Justice Byron White had sat on the Roe court in 1973. He had voted against the majority, and in his dissent he had used a phrase that would outlive him, and that the court of 2022 would now resurrect to indict the very precedent he had failed to stop. Alito quotes him by name. He writes that the Roe decision represented, in Justice White's own words, quote, "the exercise of raw judicial power." Raw judicial power. That is the phrase, written by a sitting justice on the day Roe came down, that the majority of 2022 chooses to make its own. A long-dead jurist, called back to the bench as a witness against the opinion he could not stop in his lifetime. It is worth pausing on what the majority has done here. They have taken the words of a justice who voted against Roe in the year it was decided, and they have used those words to frame the case for overruling it. They are saying, in effect, that someone on the court saw it correctly in 1973, and that the work that began in dissent now has to be finished. That signal matters because it tells us where the opinion is going. This is not preparing to trim Roe at the edges. This is not preparing to narrow it or distinguish it or wait for another day. The court is preparing to do something court opinion that overturns precedent. There is a moment where the court has to explain why. Not why the older decision was wrong, exactly. That part comes earlier. The harder question is why being wrong is enough. Because the law has a doctrine designed precisely to keep the court from reversing itself every time a new majority disagrees with an older one. The doctrine is called stare decisis, Latin for to stand by things decided, and in Casey in 1992, that doctrine did most of the heavy lifting. The justices in the controlling opinion in Casey were not mainly writing to defend Roe on its merits. They were writing to defend the institutional stability of a court that had spoken on this question and was being asked to unspeak it. Stare decisis was, in Casey, the shield. Alito's opinion in Dobbs takes that shield and removes it. Here, in one sentence, is how he does it. The justice wrote, quote, "Stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority." Listen to what that sentence does. It does not say stare decisis is unimportant. It does not say precedent is meaningless. It says instead that the doctrine cannot reach this far. That whatever weight precedent normally carries, it does not carry the weight of compelling indefinitely what the court here calls an abuse of judicial authority. The shield does not cover that. Notice also who that sentence takes down. Not just Roe. Casey, too, because Casey rested on stare decisis. If stare decisis cannot save Roe, it cannot save the decision whose entire reason for existing was to save Roe. The doctrinal architecture of two cases collapses inside a single subordinate clause. And then, a few pages later, the verdict gets shorter. 5 words, set off from everything around them. The kind of sentence Supreme Court opinions almost never contain because Supreme Court opinions are usually too careful for them. Justice Alito wrote, and I'm quoting him exactly, "Roe was egregiously wrong from the start." Egregiously wrong, from the start, not wrong in light of subsequent developments, not a reasonable decision that produced unworkable consequences over time, egregiously wrong from the start, from 1973, from the moment Justice Blackmun handed down the opinion. From the very first day of the doctrine, the court is now ending. There is, in those 5 words, a kind of historical erasure. A claim that the last 49 years of constitutional law on this question were not just incorrect, but obviously incorrect all along. The word doing the heaviest work is egregiously, not merely wrong, not even badly wrong, egregiously. A word that means conspicuously, glaringly, beyond the bounds of what reasonable disagreement could explain. That is the adverb the court chose. And to make a claim that severe land, Alito reaches for help. He reaches back to Justice White in 1973, whose dissent he had already quoted earlier in the opinion. The exercise of raw judicial power, White had written, and then Alito reaches forward to a justice who sat on the court when Casey was decided, who wrote separately in that case to say the framework his colleagues were constructing would not hold. Antonin Scalia. In Dobbs, Alito cites Scalia's Casey opinion by its formal citation. The line, verbatim, reads, Casey 505 U.S. at 979 Scalia J. concurring in judgment in part and dissenting in part. It is a small thing, a citation. A few numbers, a parenthetical, but it does heavy work. It tells the reader that the position the majority is now taking is not new. That a justice on the Casey court, looking at the same framework these justices are now overruling, said in 1992 that it did not hold together. Alito is, in effect, gathering witnesses. White from 1973, Scalia from 1992, and himself now, in 2022. 3 voices across nearly 5 decades brought together in a single paragraph to say something close to the same thing. And then, having gathered them,